Okay, we're going to pick up with the next Chapter 2 video. This is going to be shorter than the first one for Chapter 2. Wrongful reasons to reject patients. We've already talked about the fact that physicians and hospitals can refuse treatment for good reasons, and sometimes even for no particular reason, but they can't do it for the wrong reasons, and that's what we're going to talk about now. For example, the Federal Civil Rights Act makes it unlawful for physicians and hospitals that receive federal money, Medicaid, Medicare, to discriminate on the basis of a patient's race, sex, disability, or any other enumerated characteristics. The court has held that a physician may not refuse treatment if it's on a basis protected by protected from discrimination by the statute. Okay, but they left it open for the possibility of denying treatment for an non-protected status. Okay. So the first case that we are going to look at is United States v. University of Hospital. Okay, and this is a unique case because of the facts, obviously. Here we have a baby that is born with multiple birth defects. We've got spina bifida, hydrocephalus, microcephaly, what's called weak face, which doesn't allow the baby to suck or close their eyes, a malformed brainstem, her thumb was in her fist, and normally, you know that spina bifida can be corrected, and even now they're doing surgery in utero to correct spina bifida. This particular child was transferred to a hospital, was going to have the procedure done to correct the spina bifida. However, the parents decided, based on all of her other birth defects, that they were going to choose to not do the surgery and to basically, give her antibiotics so that the opening from the spina bifida in her spinal column couldn't get infected. So she'd be on antibiotics for that, but then they would just basically give her good nutrition and keep the dressing changed on the exposed spinal sac. Parents made that decision after consulting with the doctors, and then you get an attorney from Vermont, completely unrelated to the patient's family, files an action to have himself appointed as the child's guardian ad litem, and then to direct the hospital to perform the corrective surgery. Okay, now that case fails. Okay, the appellate division determined that the parent's decision was in the best interest of the infant, and there was no basis for judicial intervention, no basis to appoint this attorney as the guardian ad litem, and the Court of Appeals affirmed. Then, and this is the case we're looking at now, the Department of Health and Human Services, the federal government, learns of the case, and they file in state court in federal court. The other proceeding was in state court. They file in a federal district court that the baby was being denied medical treatment because of her handicap. Okay, so they are making what's called a Section 501 of the Rehab Act claim. Okay, and this is now the federal district court granted summary judgment to the hospital on two grounds. One, that the hospital was refusing to treat her not because of her handicap, but because her parents had not consented to the procedures. And second, the parents' refusal of treatment was reasonable given her medical options. Federal government appeals, and that results in this opinion. Okay, so there's a lot of tedious discussion about Section 504 of the Rehab Act. There is, you know, the government draws this distinction between decision making based on a bona fide medical judgment, which they concede is beyond the reach of 504, and then decision making based solely on the individual's handicap, which is covered by 504. So this is the government's argument. The government identifies that this baby's microcephaly is her handicapping condition, and because of that, they say she's being denied this surgery to correct her spina bifida, and she's being discriminated against. So the court, the language in the Section 504 says that if the individual is the handicapped, disabled individual is otherwise qualified for the surgery, then they and they're being discriminated against, then this section comes into play. And the court then says that despite the government's superficial logic, okay, that it is flawed. One, their view of otherwise qualified, in common parlance, one would not ordinarily think of a newborn infant suffering from multiple birth defects as being otherwise qualified to have corrective surgery performed or to have a hospital initiate litigation seeking to override a decision against surgery from the infant's parents. Second, they argue that baby Jane may have been subjected to discrimination, but that the government's taken an oversimplified view of medical decision making. And they go on, they quote from another case and say, as far as we can determine, no congressional committee or member of the House or Senate ever even suggested that Section 504 would be used to monitor medical treatment of defective newborn infants, which that's not very politically correct, or establish standards for preserving a particular quality of life. Here, the government's theory strains the statutory language, but it also goes against Congress's overriding concern with guaranteeing that handicapped individuals have access to programs or activities. In this present case, baby Jane Doe, as she's been called, has been treated even-handedly to the extent that the hospital has always been and remains willing to perform the surgery. It is the parents who are not consenting. Requiring the hospital to either undertake the surgery regardless of the parent's decision or to alternatively petition the court to override the parent's decision would put some huge burden on the hospital. So they, the Court of Appeals, the U.S. Court of Appeals then affirms the district court. What is interesting, and you find this in the notes to this section, is that at the publication of this latest edition, that baby Jane Doe, who's actually, her name is Carrie Lynn, is now 20 years old. She has attained a first or second grade level of scholastic achievement, which they said would not be possible. There's experts who continue to disagree as to whether the surgery to close her spine would have improved her outcome or not, but she's still living. So that's the first case that we look at with regard to Section 504 of the Rehab Act. Okay. The next case, and I don't think I assigned this to anybody to brief, is the Bragdon v. Abbott. Here we had a dentist who refused to fill a cavity for a patient unless she was willing to check into the hospital to have it done and to pay the cost for that, because she was HIV positive. And the court concluded that her HIV status constituted a disability under the American with Disabilities Act, which comes after the Section 504 of the Rehab Act. And they say that that her HIV status is a physical impairment that substantially limits one or more of her major life activities. Okay? So the court remanded the case for consideration of the dentist's defense of a direct threat to his health if he were to fill her cavity in the office. And the court concluded, because of the availability of universal precautions, and that's a key term in these AIDS cases, because of the availability of universal precautions to prevent the transmission of HIV infection, the dentist could not justify his denial treatment in terms of the need to protect himself from becoming HIV positive or being infected with HIV. So the next case, Glanz v. Bernick, is similar situation, but we're still under, we're 7 years prior to Bragdon v. Abbott, and we're still talking about Section 504 of the Rehab Act. Here we had an individual who was having some ear issues. I think that he actually had a hole in his eardrum, and he was being treated, and it just was not improving, and so they decided that they were going to do surgery. However, the patient informed the doctor, Dr. Vernick, that he was in fact HIV positive. And then the doctor tells him that he will not perform the operation, and then the patient ends up going to another doctor who does perform the surgery, but he doesn't tell that doctor that he's HIV positive. So now he is suing the first doctor for compensatory damages for pain and suffering, emotional distress, caused in the delay of having this surgery. Also for punitive damages and attorney's fees. Okay, so The defendants argue that summary judgment is appropriate for several reasons, including the ground that doctor was not otherwise qualified for elective ear surgery. Okay, and the defendant argues this is a medical opinion, okay, that the court can't override. The defendant can take into account the risk imposed both on the patient and on themselves by the prospect of surgery on an HIV positive patient. And if they properly conclude that there are risks, they must also consider whether it's possible to make reasonable accommodations to enable the patient to undergo the surgery. There was some testimony even from the second doctor who did perform the surgery who said, had I known, I would not have performed the surgery, because he didn't think that he was a good candidate because of this. And the court says that based on the evidence the plaintiff has produced, the facts are currently available, or certainly available, to warrant the conclusion that the patient was otherwise qualified for surgery, and that the defendants have not produced any evidence that reasonable accommodations could not have been made. Okay, so they say the plaintiff must first make out a prima facie case that he was otherwise qualified for surgery, and then once he proves that, then the burden shifts to the defendant to show that their handicap made him unqualified. But then the plaintiff has to be given the opportunity to prove either that the reason given by the defendant is pretext, or that the reason encompasses unjustified consideration of the handicap itself. Okay, so it kind of sets up what's the burden of proof and how it follows in a case such as this. Okay, the next case is probably one that is the most controversial of the cases that we look at, and I caution you to think about this case from all sides before you completely dismiss the court's decision and the defendant's opinion. Okay, here we had two women who were suing, had filed suit for damages and declaratory and injunctive relief against this physician. Virgil Walker and Shirley Brown are the two black females who are suing Dr. Clovis Pierce, who was an obstetrician at Aiken County Hospital in South Carolina, suing because he sterilized them and threatened to do so solely on their race and the number of children while they were receiving aid under the Medicaid program. Now, that's their cause of action. Here's the facts. This particular doctor had a policy, okay, and it was well known throughout the community. His policy was that people who were unable to financially support themselves, whether they be on Medicaid or just unable to pay their own bills, if they were having a third child, to request that they voluntarily submit to sterilization following the delivery of the third child, to have their tubes tied. If they did not wish to have this condition for my care, then I requested that they seek another physician other than myself. Okay, so this particular person, plaintiff, Virgil Walker, she goes to Dr. Pierce for what is her fourth child. They have a discussion about family planning, about his policy, and she refused to consent. She comes back again They discuss it again, and she once again declines. And she says he threatened to have her assistance cut off, although that was not proven, accepted as fact at trial. She goes to her, or actually the doctor contacts her social service caseworker and tells him what's going on, and that asks them to talk to her about sterilization. And the caseworker talks with her. He even offers to get her a second doctor. And then she goes back to the defendant doctor and signs the consent form for the sterilization. She goes into labor, she goes to the hospital, and Dr. Burke is covering for Dr. Pierce on that day. And Dr. Burke discussed the tubal ligation with her. She says she didn't want any more children. She understood it would be a permanent sterilization. She signs 2 more consent forms, so 3 total, and Pierce performs the surgery the next day. Okay, she doesn't protest any more. All of her bills were paid by Medicaid. Then she sues Dr. Pierce. The court says, we perceive no reason why Dr. Pierce could not establish and pursue the policy he has publicly and freely announced. At no time is he shown to have forced his view upon any mother. Indeed, quite the opposite. Okay, so the court finds in favor of the defendant doctor. They say he's entitled to his policy. They say he's not a state actor, and therefore he can't be found to have violated the patient's constitutional rights. Remember, only the government can violate constitutional rights, not a private individual. So, I know that is disturbing to some of you, but when you look at this case logically, you see that the doctor is entitled to that policy. This wasn't an emergency situation. She signed the 3 consent forms. She was not forced to do this. The only ramification, had she not agreed, was he wouldn't take her as a patient were she to become pregnant with her 5th child. So, that's Walker v. Pierce. Okay, so the rest of the notes on this section talk about our move from Section 504 into the ADA, the Americans with Disability Act. That the ADA applies not only to federal but also to non-federal providers of health care services, public or private. And in 1999, the Supreme Court raised the bar on the definition of disability by holding that a person is not actually disabled if medications or medical devices can alleviate the disabling symptoms. Okay, so that creates somewhat of a higher threshold for the ADA. We will stop here, and we will pick up next with the structure of the treatment relationship and forming the patient-physician relationship.